Welcome today. Hi, everybody. I'm Lori Wang, Director of Communications at Legal Aid Alberta. And on behalf of LAA, I want to thank you for joining us for this important public virtual event, Teens and Crime, What to Do if Bad Behavior Turns Criminal. So I want to start by saying we know that this is a serious topic, but we also want this to be a time where we can share information, have some conversation. So it will be a little bit informal in that way. And of course, it's 2021, so don't be surprised if you hear me say things like, hey, you're on mute. Or my second favorite these days is, can you see my screen? So don't be surprised if that happens. So today's public presentation actually came in part because LAA is working hard to improve access to justice for young people in every corner of our province. It's a more complex area of law. And at LAA, we have staff lawyers and a network of 1,200 roster lawyers in private practices across the province who also take on legal aid cases. Senior staff lawyer, our guest speaker today, Karen McGowan, has just delivered a series of professional development sessions on youth criminal law to about 80 of our roster lawyers, empowering them to provide the best possible legal representation to people who are in trouble with the law. So I'm going to be honest with you guys. So right now in my life stage, I'm a mom of 3 little ones. And so I think it's quite typical and common of me and some of my peers to be like, oh, those delinquents. But for myself, the first time I heard Karen speak, I actually felt quite humbled because I started thinking about some of the things I got into as a teen. And I'm not going to lie to you guys, I've been in some pretty bad stuff. And I can't help but think that my own life trajectory could be very different had I gotten in trouble with the law or didn't get the help I needed. And so it's quite humbling to think about and to really realize that like we're not above it. And so I'm also here to learn with you guys. And at LAA, we see this as an opportunity to share knowledge with you. And I know there's a bunch of you guys here who are lawyers, professionals, students, counselors. We have teachers and counselors from high schools here with us today. So just thank you so much for taking your lunch hour to come and join us today. I'd also like to introduce my co-host, Anayat Jetha. So he is a Legal Aid Alberta staff lawyer in Calgary who specializes in criminal law. He's among our team of many lawyers at LAA who provide services in family law, domestic violence matters, child welfare, immigration, and youth and criminal defense. So I'm going to turn it over to you, Anayat.
Perfect. Thank you, Lori. Good afternoon, everyone. As Lori mentioned, my name is Anayat Jetha. I am the Legal Services Manager for Legal Aid Alberta Criminal Trial Group in Calgary. Our role here is to represent youth and adults in criminal court. In today's session, we hope to clear up misconceptions specifically about young people and crime and give you, whether you are a parent, a teacher, a social worker, or other professional, the information you need to understand the youth justice system and how to guide young people when they come into conflict with the law. And I will take a moment to build on Lori's comments about being young and being involved in the law. One thing I've learned coming up through law school and working in different capacities is just the number of different resources that are available to people if you know a young person who's in trouble with the law. Often when we think about kids in the law, we think about police and youth court and youth detention and all the rest of it. But there are so many other resources and so many other avenues you can use to get information and to help that young person if they are struggling and involved in bad situations. So hopefully this presentation will provide you with information to help you no matter what your position is. Our main presentation will be roughly 30 minutes, followed by about 20 to 30 minutes for questions. You are welcome to send questions during the presentation by typing them into the private chat. Your questions will not be visible to anyone else. We do have more than 250 people registered, so thank you again for coming. We'll do our best to address as many questions as we can. Please remember that although there are lawyers present as part of this presentation, this is not a forum to ask for legal advice. We are here to provide insights into the law only. If you are in need of legal advice, we recommend that you visit our website at legalaid.ab.ca. However, if you stay with us throughout the presentation, we trust that many of your questions will be answered. Lastly, this event is being recorded and will be made available on our website. So we hope that you enjoy. Lori?
Thanks, Nayat. So yeah, today on the agenda, we have a quick introduction video to LAA, so you know a little bit more about all that we do. And our guest speaker, Karen McGowan, will be going over youth risk factors, when to call a lawyer, youth rights and legal options, and then we'll have our live Q&A session.
Our keynote speaker today is Karen McGowan. She is a Legal Aid Alberta staff lawyer who has been practicing youth criminal law for over 20 years. Karen is highly regarded in the justice community throughout the province as an expert in youth criminal law. She has made a difference in the lives of thousands of young people and their families. We are lucky to have her. Thanks for being here, Karen, and over to you.
Thank you. So I'm just going to try to switch screens here so that everybody can see my screen. So tell me if it can't be seen, otherwise I'm going to assume that we're good to go.
We are good, Karen. Thanks.
Okay. Just setting it up to presentation mode. There we go. Okay, well, thank you everybody for joining us for this public webinar, and I'm hoping that in today's presentation I'm going to dispel some myths and misconceptions about teens in the law. So, teens in the law, what to do if bad behavior turns criminal, and what to do when teens start to show signs of being in trouble with the law. Well, first I want to talk to all of you about certain risk factors. This is not by any means an exhaustive list, but this is a list of factors which make some teens more vulnerable to be in conflict with the law. And in no particular order, teens in child welfare care are particularly at risk for becoming involved in the criminal justice system. This is not a slam on children's services. Unfortunately, it's the nature of the beast. When a teenager is suddenly removed from their home, owing to neglect or abuse, maybe parent is has been taken to jail, is in rehab, drug addiction issues, doesn't matter. Doesn't matter what the issue is with the parent, there is still a strong bond between the child and the parent. And when these teens suddenly find themselves in group care, sharing accommodations with strangers, locks might be on the cupboards and fridges. Anybody who has a teenager right now will tell you that teens can eat you out of house and home. So this is a necessary evil of living in group homes. And unfortunately, you know, the staff are strangers to the young person. And, you know, the other kids in the group home might be difficult to deal with. And this is certainly not an ideal situation for these young people. So this creates tension and conflict, and quite often my client's very first criminal offense is related to an offense that occurs inside the group home. So, a staff member might tell the teen to go to their room. The teen says, "You're not my parent, I can do what I want." There might be an altercation, maybe there's a hole punched in the wall, maybe the worker is shoved, and lo and behold, the police are called, and now the young person is introduced into the criminal justice system. The other important factor is Indigenous teens. They are most particularly vulnerable from all different levels. One is the obvious historical and current prejudice or bias that occurs with First Nations people, but also the history of colonization in Canada and what happened in the residential schools and the intergenerational trauma that comes from that. I can't express enough how serious the residential school situation was and how the repercussions go down generations. If you were to call it a residential school is a bit of a misnomer. It kind of makes it sound like it's a boarding school and you're being sent off to Eton. This is quite the contrary. Picture yourself, a 5-year-old child ripped from your mother's arms. And I'm not trying to be dramatic. This is literally what happened. They were forcibly removed from their homes, and they weren't put in schools. They were put in institutions like a prison. So imagine being abducted at the age of 5 and your captor is abusing you physically, sexually, mentally. They are quite literally beating your culture out of you, your language out of you, and everything that you've ever known. And if you think that you come from a place like that, and when you're suddenly released from this institution that you're going to be a well-adjusted individual, I've got news for you. That's obviously not the case. And because these people, when they come out of these residential schools, they too find themselves as parents. And you and I will parent our kids according to what our parents and our grandparents did. But if you didn't have any parents or grandparents, how do you know how to parent your teen? So this trauma does get passed on from individual to individual and does not end with that 5-year-old finally being put back out onto the community. Similar to this is victims of domestic and sexual abuse. You have probably often heard the phrase, "stop the cycle of violence," and that's because there too there is intergenerational trauma coming from domestic and sexual abuse. Sometimes the victims continue to be victims themselves, but often those victims then become the perpetrators themselves of abuse. Obviously, homelessness and poverty. If you can't fend for yourself, you can't supply food, clothing, shelter for yourself or your loved ones. Sometimes you turn to crime in order to facilitate that. Cognitive impairment, like fetal alcohol spectrum disorder, is particularly vulnerable teens in relation to that. So cognitive impairment can be for anything, but more often than not, it's the fetal alcohol spectrum disorder kids. And this is a situation where their ability to connect actions with consequences is harmed. There may be delays in other aspects. There tend to be more impulsive, less ability to rationalize and logically figure things out on their own. And quite often these FASD kids are, they're used as mules by older and wiser teens or adults because the FASD kids want to please other people. And quite often they are quite literally holding the bag. So they might make that young person go in to commit a crime, and then when the police show up, everybody scatters and the kid is literally holding the bag. Never underestimate negative peers and the power of peer pressure. Even the best kids can fall prey to this. Obviously, addictions. If you're not thinking clearly, you're making decisions based on feeding your addictions, and you're committing crimes to continue to feed that addiction. Childhood trauma is relatively self-explanatory and is basically covered by all the other ones that I've just mentioned. And then lastly, teens without pro-social activities. So kids who are bored are more likely to get in trouble. You might have heard the old adage, idle hands is the devil's work. Young people who are bored tend to get into trouble. In my experience, I've often asked kids, because I still have my own trouble trying to figure it out myself, you have a young person who's charged with slashing tires or breaking windows, and there's like no value in that. I mean, it's not feeding your addiction. You're not getting money from it. What's the point? And quite often my clients are telling me that they had nothing better to do. It seemed like a good idea at the time, or they simply don't know. So keep the teens occupied, and that could reduce the risk factors. So some of you might be sitting there thinking, well, not my kid. He or she doesn't have any of those risk factors. Well, while most crimes are committed by teens with certain risk factors, they don't all fit the mold. Some teens who find themselves in criminal court do come from the more ideal socioeconomic backgrounds, more privileged backgrounds. Typically, they are the one-hit wonders whose brush with the law was enough for them to stop, for example, shoplifting. However, some criminal offenses know no socioeconomic backgrounds, but in my experience is more common among the affluent teens, such as child pornography and sexual assault. And some of you might be gasping at that, and that's because typically these, quote, good kids, they're not robbing people, they're not breaking into anything, but there can be mistakes when it comes to sexual relationships. Even ourselves as adults sometimes have difficulty navigating ourselves through relationships, but imagine how even more confusing it is for a teenager who has zero experience with sexual relationships. And sometimes they might rely on movies or TV, and unfortunately really old movies where certain behaviors were a little bit more countenanced. We've now moved away from the theory that boys will be boys to the Me Too movement. Make no mistake, if a young person grabs another teenager's buttocks, that is in fact a sexual assault, and they can and will be prosecuted for that. So I just want to take a little bit of a moment to talk about sexual boundaries and the issues of consent. So young ladies are not walking around the street with signs on their heads saying, go ahead, grab me. And it's not until you grab them that then when they say no, that you stop your behavior. It's the other way around. You should consider the young lady in question to have a sign on her head that says, do not touch me. You need to ask for consent. Now, what is the age of consent? Well, the age of consent in Canada is the age of 16. So what that means is a 16-year-old youth can have a relationship with somebody who is older than them. It doesn't matter what the age is. So long as that older individual is not in a position of trust, they're not in a relationship of dependency or exploitation. So you're thinking, well, if the age of consent is 16, oh no, my 16-year-old son is dating a 15-year-old girl. Well, not to worry, Parliament thought of that. So there's age exception rules. So the cutoff is actually 12 as far as teenagers amongst themselves go. A 12-year-old cannot be having any kind of sexual contact with anybody younger than them. That's the cutoff. However, a 12 or 13-year-old youth can have a relationship with somebody who is less than 2 years older than them. So they go by the birth dates of the respective parties. So the 14-year-old boy can date a 12-year-old if that 12-year-old is consenting to the activity. Again, they're capable of consenting for this purpose. And they go by the birth dates of both those individuals. So if this is a freshly turned 12-year-old and the teenager is like 14 going on 15, then there's going to be a problem there. And then when you're dealing with the slightly older teens who are 14 or 15 years of age, the age gap now improves to 5 years. So the 14-year-old teenager can consent to a sexual relationship to somebody who's, let's say, 18 or 19. So there's the 5-year gap. And sexual boundaries, again, just knowing that it's hands off until there's explicit consent by the other party. Now, what about child pornography? We're in a day and age where everybody's got a cell phone, everybody's got a camera, your kids are on TikTok, they're on Snapchat, they're on all these kinds of devices. You and your child need to be aware that if the teen were to take pictures of themselves and pass it on to somebody else, and that somebody else decides to show their buddies, hey, look at my hot girlfriend, and they share that, that becomes distributing child pornography, and you can and will be prosecuted for that. If you are the, quote, victim of the child pornography, then you need to be aware that once the image is out there on the internet, it's there for good, child pornography or not. So do speak to your children about sexting about consent and about sexual boundaries. Okay, so there might be some parents out there that might think that maybe their child could use a lesson or two. So parents may want their children to learn consequences from bad behavior, and of course we do, but that is better left to parental discipline. Some parents are so fed up with their teens' out of control behavior that they do call police. However, you need to be aware that once police are called, it is no longer in the parents' hands whether they are prosecuted. So once police are called, the police take it from there, and it doesn't matter what really the parent says. It's up to the prosecution to decide whether to proceed to trial or not. Parents might also believe a night in jail, so that's EYOC or CYOC, that stands for Edmonton Young Offender Centre or Calgary Young Offender Centre, that it will scare them straight, but they may end up making friends with negative peers. Typically, the young people that are in these institutions, they're there because they were denied bail, meaning that they have maybe violent tendencies, they have a criminal record that merits them being detained because they're kind of a danger to the public maybe. Or maybe they've been sentenced to a period of incarceration. Typically, young people don't go to jail for their first offense unless it's extremely serious. So the friends that they're making could be very negative peers. They could become now further entrenched in the criminal justice system, or worse yet, be recruited by gangs. So no, leaving them overnight in EYOC is a bad idea. I don't know where parents get this from, but I often hear that they are being told by somebody that having their child arrested is the only way to get a psychological assessment to find out what's wrong, but they are only ordered for most serious offenses in very restricted circumstances. So if you think that, you know, your son or daughter's criminal behavior is going to result in psych assessments, it's not going to happen. You're going to have to find other ways, and we'll talk about resources in a moment. So let's turn now to police interviews. Let's say you get a call from the police and they want to interview your child. So your role as the parent or guardian, so anytime I say parent, I also mean social workers. A parent or guardian can obviously best help their child by protecting their rights and supporting them through the process. So often what we hear is police might insist that they need to interview your child, and it's up to the parent to bring that child in. Well, here's a tip for you. 90% of the time, these interviews are in relation to sex assault charges. So they've received a criminal complaint from a complainant indicating that your son or daughter is the subject of an investigation for sexual assault. Typically, sexual assaults have no witnesses. There's no video recording. It's the proverbial he said, she said. And the reason they want to interview we're going to assume it's a son for a moment, just going by most of the time it is. They want to interview your son because they want to get, quote, his side of the story. I can assure you that if the police actually had all the evidence that they needed to properly prosecute your son, they wouldn't be needing an interview. So if the police call and say that they need you, not can you, they need you to bring your child in for an interview, you should probably clarify with the police, are you looking to simply interview my son or daughter, or are you looking to arrest them? If the police say, no, we're just interested in interviewing them, then you can simply answer, well, I'm sorry, I'm going to decline. Thank you very much. And end the conversation there. If the police then say that, well, we're looking to arrest your son or daughter, then yes, you are going to have to take them in, because you either be cooperative in the sense of bringing them in for the arrest process, or they do it the hard way, which is issuing a warrant for the young person's arrest and actually physically bringing them to the police station. So get the clarification ahead of time from the police. Is it an interview or is it for arrest? So be aware that if the teen speaks to police, this might actually provide the police with exactly what they needed to prosecute your teen. Again, if they have the evidence that they needed, chances are they didn't need to speak to your teen at all. And the only way that they're going to have a successful prosecution is if your son or daughter makes a statement to the police that they could possibly use against them. And I'm going to give you one example. I had a youth who was alleged to have met up with another young lady on Tinder. So they didn't know each other. They only had like first names and a picture to kind of go with. A sexual assault allegedly occurred. The young lady went to go report to the police, and all she had was a first name, the race of the individual, and she did her own research on Facebook, and she found an individual that appeared to resemble the same person and had the same name. So she went to the police with that. Now, the police had absolutely no idea that the individual that they were about to speak to was for sure the guy, and what they really needed from him was an admission that he knew her. So that teen was given the advice, don't talk. Anytime they ask you a question, say, I'm not speaking, I need a lawyer present. So the young person, spoke up for his rights, said, I'm not talking to you without a lawyer present. And the police officer said, well, that's fine. I'm just going to tell you what the offense is all about. And the police officer did ask one question, and he said, so, we got this story by Jane Doe, and she says that, she met you on Tinder. You look a little bit puzzled. Do you know who I'm talking about? And all he did was nod his head in the affirmative. That nodding alone was enough to have him charged. If he had not nodded at all, they wouldn't have had enough evidence to probably even lay a charge. So if the police are seeking to interview your teen, please call a lawyer. Legal aid staff lawyers like myself will provide advice to you and your teen. So before heading into an arrest situation, please call us. And if the young person is at the police station, that number is posted next to the telephone. So they just call the youth line, and they can obtain immediate free legal advice from Legal Aid, no matter what time of day that is. So you're now at the police station. You brought your son or daughter in, and you're thinking that they're just going to be arrested, but they may still try to force an interview. Because the right to speak to and have a parent and or lawyer present during an interview is the child's right, not yours, you will have to ensure your teen knows to ask for you and a lawyer. So the right to a parent belongs to the young person. You don't have a right to be with the teen. And even if you spoke with a lawyer before going into the police station, please call again when you arrive. You may have been given very good advice, but when you hit the police station, you might be in a bit of a panic and forgotten much of what was said to you. So again, Legal Aid has free 24-hour on-call service staffed by individuals with extensive experience in youth practice. So we've moved beyond the interview process. Let's assume that your son or daughter kept their mouths shut. They didn't make any statements, but the police are still going to charge the young person. So what happens once they've been arrested and charged? Well, don't worry. Depending on the charge, first-time offenders are typically released back to the parent, and this might happen by something called an appearance notice, which is a piece of paper, a formal document that says you have a court date on this date. In more serious offenses, there is the possibility of a bail hearing occurring before a justice of the peace, which you should be present for. So this is kind of like a court system outside of the courts where justice of the peace sit virtually any hour of the day with a small rest period late at night. And that individual is going to decide whether or not your son or daughter gets released. But like the 24-hour legal advice line, Legal Aid also offers free duty counsel services at this stage. So there will be an actual lawyer present who will represent your son or daughter at the bail hearing stage in order to secure their release. And the law says that your teen, any person, not just teenagers, but anybody who is arrested must have a bail hearing within 24 hours of their arrest. So your patience is required. There could be a full moon, there could be a lineup, there could be a queue of people waiting to appear before the justice of the peace. And I'm just going to reiterate again, you're going to get into that queue a lot quicker if you end that interview immediately. They'll have to then process you. If you start engaging in the interview, that could be a 2-3 hour interview, and now the ability for you to get released gets a little bit pushed a little bit further back in the queue. So apart from, don't make a statement because that could end up giving the prosecution what they need. Talking certainly does not speed things up at all. Okay, so now you have a court date. Now what? Well, if your teen was released on an appearance notice, there should be 2 dates on it. One would be a fingerprint date, and the other is the court date. So the fingerprint dates, the young person has to go down on the date of, have their fingerprints taken. If the young person misses either or both of the fingerprint court date, warrants for their arrest can be issued. So they must attend both. You need not do anything else before court. Simply proceed straight to youth court and look for duty counsel, who will then help your teen navigate their options. First-time offenses like mischief, simple assaults, and thefts are usually eligible for a program called extrajudicial sanctions. And what this is a system of diversion that allows the teen to receive a consequence without pleading guilty or receiving a criminal record. There may be exceptions to who might be eligible for EJS. So even the simple assault charge, if it's a domestic would be defined as including assault on mom or dad or anybody in the home, as well as an assault on a romantic partner as well. Also group assaults are usually excluded, so like a 2-on-1 unfair assault, those typically are not approved for EJS. If there is a legal defense or the offense isn't eligible for EJS, a duty counsel will refer the young person to legal aid and adjourn the use matters for the appointment of counsel. So you want to get a lawyer. How does my teen get a lawyer? Well, all teens, regardless of parental income, are entitled to a lawyer. So it doesn't matter if your dad is Donald Trump, Barron Trump is still entitled to a legal aid lawyer. And while it is not free, the cost of a lawyer is a fraction of what you might pay for a private retainer, which the youth will owe later on when they're obviously in a position that they could pay it back. And payment may be offered in installments according to their ability to pay. For information on how to apply, you can go to our website at legalaid.ab.ca. So legal aid will appoint a lawyer like myself from a staff office, or you may receive a lawyer in private practice who has experience in youth court. It is the youth that must apply, not the parent, and information about who the lawyer is can only be disclosed to the teen unless consent is granted to the parent to obtain that information at the time that the application is made. Some of you might be very anxious about how do I talk to this assigned lawyer, and I do receive a lot of calls of anxious parents wanting to talk to me before the file has even hit my desk. But you need to understand that the teen is the client, not the parent. So do not be alarmed if the lawyer wants to speak to your child before even talking to you at all. Lawyers have certain ethical obligations of fidelity to the client, and they may be limited in what they are for you to discuss with parents. This becomes further complicated if the parent is the person that reported the crime or is a complainant of the crime, because that puts the lawyer in a conflict of interest, and they obviously can't discuss too much with a witness to the prosecution. So we're not trying to exclude you for any other reason than that we're trying to protect our clients' rights and protect our ethical obligations. A lawyer-client privilege only exists in private, so once a third party is included, that privilege evaporates. So yes, you, the parent, is a third party. And the last thing a parent wants is to become privy to some information that if, for whatever reason, they became called as a witness, they would then need to disclose, because you can't lie on the stand, that would be perjury. So it's better that you're not present. In the same vein, please don't ask your son or daughter about the details of the offense. If word got out that you received a, quote, confession from your child, you could then, again, be made a witness for the prosecution. The only way for a lawyer to best represent youth is if he or she is open and honest with a lawyer, and having a parent present often inhibits honesty for fear of judgment or punishment from the parent when they get home. So for all of these reasons, this is why I might exclude the parent from being involved in discussions. Generally what I do is after I've interviewed the young person, I've received the information that I need, I will then invite the parent in to explain to them what the criminal process is and what will happen going forward, but I do not disclose anything that we discussed or even what was disclosed in the police reports or witness statements. Youth criminal records. These are something that could haunt a young person going forward. The Youth Criminal Justice Act is designed to rehabilitate and reintegrate young people to become contributing members of society. And this is like the whole reason why you'll see that a young person's name can't be published and they hide the identity, because the hope is that we rehabilitate that young person and we don't want their identity or their record following them going forward. But unfortunately, the record can pose some problems. So as long as the young person completes whatever sentence they received without incurring new charges, the record will be sealed or destroyed after 3 years from the completion of that sentence, or in the case of summary offenses, and 5 years in the case of indictable. And you're probably like, wow, Karen, slow down. This is a bunch of mumbo jumbo. So what that means is, let's give you an example. Your son or daughter commits a criminal offense on their 16th birthday, or is convicted of a criminal offense on their 16th birthday, and they're given a year's probation. So that year probation expires on their 17th birthday. Now, if the Crown had proceeded by summary conviction, that's 3 years. You count from their 17th birthday, 3 years. That takes them to 20. And if they went by indictment, it's an indictable offense, that then extends it to 22. So what's the effect of that? Well, despite popular belief, the record does not disappear after the age of 18. So let's say the young person commits a brand new offense right after their 18th birthday, but before that access period has expired, the youth record will then follow them into adulthood and become part of an adult record. Young people are best advised to avoid applying for the types of jobs which require security clearance checks during that access period, and avoid travel where they could become flagged as a criminal offender in that other country. So just to break that down a little bit for you, they call them security clearance checks. They're sometimes called criminal record checks. Technically, it wouldn't be a youth record, but it is something that can be disclosed to other departments, like when you're applying for jobs. The trouble with the travel is, and I'm going to use the example of the United States because that's probably the most common situation where you're traveling to. So, you want to go to Disneyland with your parents, and you have this criminal conviction. The border agents may have access to the CPIC, which is the RCMP criminal database for criminal records. Or if you admit that you have a criminal record, they can flag you. So they put like a note on you that you're a criminal offender. So even after that period has expired and they can no longer access that information, the problem is you've already been flagged as the criminal offender. So that could have lifetime consequences for you. So I strongly advise that if you're considering travel, that you speak to an immigration lawyer to get more detailed advice. But my preliminary advice is avoid it until that access period expires. How do I help my teen? Well, if your teen is abusing drugs to the extent that they can't function, they're not thinking straight, they are high 24 hours a day, and they pose a potential threat to themselves or others, you can contact a program called PCHAD, and that stands for the Protection of Children Abusing Drugs, who can assist in helping your teen be detained for the purposes of detoxification and treatment. Their number is 1-866-332-2322, or you can go to the Alberta Health Services website and just do a search for PCHAD. You don't need to scribble this all down. There'll be a link to all these resources in a moment. If it's alcohol and drugs as well, but it's not drugs to the extent that they need to be detoxed, but they do obviously need to address their issues, you can contact ADAC, and their number is 780-422-7383. And if your teen poses a danger to themselves or others, you can call the Children's Mental Health Crisis Line at 780-427-4491. This next one I put in there just in case you become aware of a teenager that's in need of intervention because they are abused or neglected. The Child, Youth and Family Enhancement Act does provide authority for child and youth services to provide services in support of children who are abused, neglected, or otherwise in need of intervention. Let me be very clear, loud and clear. CFS does not get involved if the behavior of your child is the issue. The issue has to be that they're abused or neglected. And please do not be calling children's services because you disagree with another parent's form of discipline if it's not actually abusive or is neglect. Remember when I talked earlier about risk factors, sometimes being in the care of children's services can put the young person more at risk of criminal involvement. So the crisis line is 422-2201. And lastly, call 211. They are a wealth of information, and they can give you more information regarding other kinds of resources to help you and your teen. Here are some of the website links. You can find this exact page on our legalaid.ab.ca website to help you find the resources necessary for your child. So how do I prevent my teen from even getting into trouble in the first place? Well, first and foremost, never underestimate the power of peer pressure. It is a powerful drive to criminal behavior, so learn who your teen is spending time with. Keep your teens busy. Teens who are active in pro-social activities are less likely to commit crimes, so find whatever their passion is and foster it, whether it's art, music, sports, whatever the case may be. Speak to your teens about sexual boundaries and consent. No means no. It's the Me Too movement. Make sure consent is obtained by the partner before proceeding further with that sexual activity. Remind your teens that sexting might result in child pornography charges if images are shared, and that once an image is out on the web, it is there forever.